Welcome, everybody. My name is Elena Popp. I'm the Executive Director of the Eviction Defense Network. This is our presentation on general tenant rights and tenant rights under COVID. While there are spaces in the presentation where I can stop for questions because we're recording it, we're just going to plow through the whole presentation and at the end stop the recording and ask for general questions. So I am with, the Eviction Defense Network. We are an organization that believes that housing is a human right, and we want to close the access to justice gap for tenants facing eviction in LA County, meaning we want everyone to have a lawyer to go to court with them because 99% of tenants that go to court alone lose their cases. We are also at the forefront of the battle to stop gentrification and displacement in LA County. In this presentation, we're going to cover an overview of housing rights and rent control laws, an overview of the current COVID-19 non-payment laws, whether or not you can be evicted for other reasons other than non-payment, what to do about landlord harassment, special issues for tenants in illegal or unpermitted bootleg units, cash for keys offer, what to do if the landlord comes to you with a voluntary vacator agreement or a cash for keys offer, a little bit about the eviction process, although I will tell you that every Saturday morning at 9 a.m., we have 2 to 3 hours on just the eviction process. The webinar is from 9 to 11, and then we'll stay and answer questions until the last question is answered. I think today we were on until 12:34 answering questions. So come to that. It is different than this. And how to send declarations, rent, and other important documents. Finally, how to pay rent like a pro. The Eviction Defense Network is part of an organization or a coalition called the Right to Counsel Coalition. We were founded in 2018 with a goal of securing a statutory, meaning a law, right to counsel, a law that guarantees tenants the right to a lawyer before they are displaced, much like the public defender's office. Before we take someone's freedom away, we make sure they have a lawyer. Tenants should have a lawyer before their housing is taken away. And frankly, when they have a lawyer, the housing generally is not taken away, or in 98% of the cases, we either secure a victory, they get to stay, or a victory, they get to move out with enough money and time and to be able to make a smooth transition someplace else. The Right to Counsel Coalition uses organizing to change policies, change laws, educate people about those laws, and provide legal assistance to enforce those laws. During the pandemic, we have developed a project with funding from the County of Los Angeles and the City of Los Angeles, and also a little funding from Santa Monica and Long Beach. I think eventually every city in the county, there's 88 of them, should pitch into this program so that we can guarantee representation to every tenant facing eviction. This StayHouseLA works like this. You can go on the website and click here where it says Know Your Rights and tool around and read much of what I'm telling you in a more summary set of wordings, and it's in writing. Or you can click here and find other workshops. I encourage you to do that. The Eviction Defense Network does 3 general workshops a week, Tuesdays, 6 o'clock in Spanish. I really encourage English speakers not to come to the Spanish workshop. It means that we spend more time translating and the presentation is very long. So please come to Thursday English speakers at 5 o'clock and then on Saturday at 1 o'clock. We also do the more specific what to expect in an eviction process, or the title of it actually is the eviction process turning a negative into a positive, how you can actually get ahead instead of being a victim to an eviction process. And we give you very specific examples of tenants who have bought houses because of the work we did with them during the eviction process, and tenants who have saved their homes or saved their buildings because of the work that we did with them through the eviction process. So I encourage you to go to the other workshops. So come to our workshops, but then also explore and go to other workshops, because you should hear from other speakers. You should not be getting other points of view. We've sort of agreed on what the law is. If you are at another workshop and someone says something different from what I've said, please do not argue with the presenter. Please don't say Elena Popp said. Instead, come back here, tell me what workshop you were on, who the speaker was, and what they said. And I will either correct my presentation if I think that I'm wrong, or I will call them and find out why they think it's something else. These laws are very complicated, and there are a lot of issues and different interpretations about how the laws work with each other or don't work with each other. And we've had a lot of discussions about what we are arguing and what defenses we are raising, but there are still some disagreements between lawyers. The other day in a workshop, another lawyer and I had a disagreement. It was an honest disagreement. And the benefit of having that honest disagreement in front of people is that people got two different views. One lawyer thought it was one way, another lawyer thought it was another way. You need to decide which of the two lawyers you're going to listen to. If there are gray areas, and there are a lot of gray areas. On this website, you can also get legal help. At the end of the presentation, I'm going to tell you where to go, what website to go to if you want help from EDN, from the Eviction Defense Network, and where to go if you really don't care whether it's us that helps you or one of the other 11 legal services programs. And so you click here, fill out a questionnaire. You are immediately given the name of the two agencies that will help you, a legal services program and a community-based organization. These are the legal services programs. So Asian Americans Advancing Justice, Betzedek Legal Services, Legal Aid Foundation of Los Angeles, Neighborhood Legal Services, the Eviction Defense Network, Heart LA, BASTA, Community Legal Aid, SoCal, Public Counsel, Inner City Law Center, and the Housing Rights Center. These are all the 11 legal services programs in the County of Los Angeles that help people for free. We are all part of the one coalition. When you put your information on the StayHouseLA workshop website, you are given a disclaimer that says that all of these agencies will be able to access that information, which could have a little impact on the attorney-client privilege, meaning the right to have all of the information you tell a lawyer be completely confidential. So we ask very little information on the website. But all of these agencies will be able to access it, and you will be assigned to one of us. At the beginning of the pandemic, we were letting people shop around, okay? Meaning, oh, I don't really like what NLS told me, so I like better what Basta's telling me. So then you would get like 2 bites at the apple and 2 agencies, but it is a waste of time. It is a waste of valuable resources. So we're not letting you do that. So whatever agency you are assigned is your assigned agency, and you cannot shop around for better opinions. You can come to workshops, and if you don't like what your lawyer is telling you, I am happy to help you understand what your lawyer is telling you. Sometimes it's just that you aren't understanding. Sometimes it's that they're not explaining clear enough. Sometimes it's that it's complicated. Sometimes is that the news your lawyer is telling you is bad news. I had a discussion with one of the organizers who was telling me that the lawyer representing one of his members was being so negative, and there doesn't seem any and so he wanted my opinion. So I started listening to part of the case, and the truth is that sometimes there are no defenses. Sometimes the law doesn't support the tenant. Sometimes the evidence isn't good enough. Happy to look at that and to help you communicate with your lawyer if you come to the webinars and to my office hours. Kevin will put up the webinars right now, and then the office hours, so that people will know how to link up. I'll say this a couple of times during the presentation. At the webinars, you come in, there's a presentation, there's general questions and answers, and then there is, if time permits, one-on-one consultations. If time doesn't permit, you get scooted over to either Monday, Wednesday, or Friday at 6 p.m. No presentation Monday, Wednesday, or Friday at 6 p.m. You link in and you're held in the waiting room, it says waiting for the host to let you in. And in the chat for the waiting room, I will say, I just let in Frank, then is Mary, Joe, and whoever else. So you can see where you are in line and how approximately how long it's going to take. But please don't disappear from your computer. People disappear from their computers because they think it's going to take another hour. And then eventually, if enough of you do that, there's no one for me to interview, and I will just leave because I'm not going to sit around while you come back from your lunch or dinner break. Okay. So you have to be attentive to the computer when I call your name. When I call your name, please connect to audio immediately, because you've been sitting in the waiting room. People forget that you actually have to connect to audio and then unmute. So we take about 2 or 3 minutes per person doing that. If I'm seeing 15 people, you can imagine that that becomes a waste of time. So please connect to audio and unmute immediately. Okay. So you're assigned to one of these 11 legal services programs. We're all working together. We do share information. So when I am stumped on a case or I don't think I can win, I will put out, without using the client's name, the facts of the case to get other input. And other of the lawyers also do that. We're on a listserv all together, working sort of like one great big law firm. With about 70 lawyers, which is a much more efficient way to provide services to the nearly 500,000 people that are at risk of eviction in LA County right now. Then these are the community-based organizations. These are organizations that do tenants' rights organizing and education. ACE, CBE, CES, Eastside Leads, East Side Yards Communities for Environmental Justice, Inquilinos Unidos, Los Angeles Center for Community Law and Action, Northeast Los Angeles County Coalition, and the Strategic Actions for a Just Economy. These organizations will help you maneuver the system, will help you work with your lawyer, might help you gather the evidence. What they're mainly are doing is building a base of tenants that are willing to come to the table and help fight for stronger rights. Okay, they're building a tenants' rights movement. Again, back to the StayHouseLA website, Get Legal Help is the button for being assigned a lawyer. We have a digital divide hotline. I, however, prefer to take a tough love approach on the digital divide issue. I am 62 years old. I was born and raised in a world in which I sent a letter to someone and 2 weeks later I got a response. I now live in a world where people will text me, why haven't you responded to my email that they sent me a half an hour ago? So um, I am not a child of this technological age. In fact, pre-pandemic, quite resistant to a lot of the sort of hustle and bustle and buzz and fast information overload of technology. But during the pandemic, I've come to realize that if you have a digital divide issue, then you are divided in very significant ways from essential information, essential services. So we are not doing our friends that say, oh, I'm not very good with technology. Oh, I'm not very good with computers, which is me. Okay. I have banned those statements from my uh, mindset. Okay. I am good with computers. I am good with technology because I have to be, because if I am not, I'm divided from information that I need in a very significant way. There are ways to get smartphones. Our smartphones have more processing power than desktop had when computers first came out, even when we first started getting on the internet. So everybody should have a smartphone, and there are government funded smartphones for people. But we nonetheless have a digital divide hotline. You can call here, speak with a live person. What that live person is going to do is put you into into Get Legal Help. So it's just an extra step. It's really a delay. If you know someone that has a digital divide issue, just go ahead and help them fill out the application, because it is the fastest way to get help. This StayHouseLA program is sponsored by the LA County Department of Business Affairs, and I should add a slide for LA, Long Beach, and Santa Monica. Kevin, can you make a note in the chat that I should do that? Okay. Briefly on language justice. I should have started the presentation by making sure there were no Spanish speakers on the line. I'm sure Kevin would have told me if there were, in which case we'd be making the presentation in English and Spanish. So language justice is the right to participate in the language that you choose. So generally we ask people to be patient with interpretation when we do that. But we also acknowledge that this is already a very long presentation and it doubles in length when I'm doing it in two languages, which is why we set up the Tuesday for Spanish, the Thursday for English. Saturday is bilingual. If somebody comes on a Saturday, we did this morning, we did it in English and Spanish. Oh no, actually nobody identified themselves as a Spanish speaker. So we did it in English. But last week it was in English and Spanish. So we will accommodate language needs. The attorney-client privilege means that anything you say to a lawyer is confidential and private. So if you talk about private specific issues during a group meeting in front of a lawyer, you may be giving up that right. For that reason, we require that you keep your questions general. If it's me, I'm going to stop you. You can ask a question is, if a tenant has gotten a 3-day notice to pay rent or quit, what should they do? We don't want the question to be, I lost my job and then I got a job and then I lost my job again and then my mother died and then my uncle died and I sent the money for the funeral. We don't need all of that. What we need to know is what the notice is that you've gotten. And we don't need it to say, I got a notice. If a tenant got a notice, bloody, what they should they do? Now, truthfully, is if you're listening to the presentation, you will already know by the end of the presentation what to do with any notice that you might have gotten, because I cover it. And if it's not covered here, it's covered Saturday at 9 o'clock. But people sometimes need to hear it as though it's directly for them. So we will do the one-on-ones as time permits. The thing about confidentiality is that if you disclose personal details in front of a group, it's like going to confession with a few friends and strangers. Suddenly your confession is no longer private. So there will be the one-on-one for questions. Okay. I like to start with rent stabilization when I explain rights. Why? Without rent stabilization, you have almost no rights. In the state of California, a tenant that does not have rent stabilization protection can be evicted with a 30-day notice to quit no cause if they've been on the premises less than a year, 60-day notice to quit no cause if they've been there a year or more. Without rent stabilization, the landlord can raise the rent to market whenever they want. They can raise it however much they want. They have to give you a 30-day notice if the increase is less than 10% and a 60-day notice if it's 10% or more. Without rent stabilization, you have almost no protections. We currently have a statewide rent stabilization law that and so most tenants in the county of Los Angeles have some form of protection. And because of that, truthfully, the lives of tenants and the advocates that help them have changed dramatically since that law went into effect January of 2020. Before January of 2020, it was not unusual at a clinic for us to see 45 people, 45 households, and 40 of them, the message was, I'm sorry, but this notice is legal. You don't have any protections against this 30-day notice to quit no cause, 60-day notice to quit no cause, huge rent increase, no protection because your unit is not rent stabilized. That changed when the Tenant Protection Act passed, and I'll give you a little bit of history of that law later in the presentation. So what is rent stabilization? Rent stabilization, often called rent control, although this is a misnomer, it's really stabilization, are laws that address when and how much the rent can go up. What are the limits? They don't prohibit rent increases, but they limit rent increases. They also dictate the reasons that tenants can be evicted. They lay out, each law is different. In the city of Los Angeles, there are 14 reasons that a tenant can be evicted. The first 7 is the tenant doing something to violate the lease or breaking the law or not paying the rent. The last 7 are the landlord wants to do something else with the property, like live there themselves or move in a relative or a resident manager, or or demolish and build something else, convert to condominiums, etc. Rent stabilizations also dictate what happens if you are given an amenity at the beginning of the tenancy. So you rent with parking, laundry facilities, a recreation room, a pool, a jacuzzi, things that are not required under the law, things that are not required in order for the unit to be deemed habitable. And then the landlord tries to take it away. So you can imagine if you live, for instance, in a neighborhood with very, very little parking, say Venice, and you rent with a parking space, but then they take it away, they're taking away something really significant. I used to walk 10 blocks when I lived on the boardwalk and I didn't have a parking space. Sometimes I'd have to walk 10 blocks at night to because I couldn't find parking any closer. That's like a mile, right? So parking can be a very important quality of life amenity. If it's taken away, well, rent stabilization laws provide some protection. Some of them just say you can't take the amenity away. Some say you can't take an amenity away if the reason you're doing it is to force the tenant to move out. And some of the laws say you can take them away, you just have to lower the rent to correspond for what the tenant is losing. I think there are people on this webinar who are facing that. They're facing the loss of a garage and parking, and they don't want to lose the garage and parking because it's the amount of money the rent will be reduced will not really compensate them for the loss of that amenity. Uh, so, but that is the law. And it's not fair and it's not right and it's not just, but it is the law. So what do we do about the fact that that is the law? Well, get involved and maybe we'll make a campaign to change the law in the city of Los Angeles so that it's stronger the way it is in the county rent stabilization law. It is important to note that there is no actual rent control in California. And the reason for that is a concept called vacancy control. Vacancy control. When there is vacancy control, the new tenant pays the same rent as the previous tenant, regardless of the reason that they are moving out. The rent for the unit is protected. So tenant moves out voluntarily, new tenant pays the same rent. Tenant is kicked out because they broke the lease, new tenant pays the same rent. It takes away the incentive to evict people, right? Because the landlord isn't going to make any money by being able to evict someone because the new tenant's going to pay the exact same rent. That's the difference between rent stabilized and rent controlled. We used to have rent control laws in the state of California. The West Hollywood law was a rent control law. The Santa Monica law was a rent control law. The LA law was always a rent stabilization law. Why would we have only done rent stabilization in LA instead of rent control? Well, because it's what we could get. When it's not like we say we're going to make a law to protect tenants and then there's no opposition, right? Whenever we try to make a law to protect tenants, there is opposition. And so that means we have to be stronger than our opposition. Our opposition always has more money than us. We have more people, but elected officials fear money. They fear the kind of money that the landlord lobby can put in against them to get them out of office. And so we have to show them that we have more soldiers that will also present a threat to their reelection if they don't do the right thing by tenants. So in 1995, a law called Costa Hawkins was passed. Costa Hawkins is what took away vacancy control from Santa Monica, West Hollywood, and other jurisdictions that had it in the state of California. And it prohibits any jurisdiction from having vacancy control. And vacancy control is the holy grail of the landlord lobby. They care more about vacancy control or vacancy decontrol, that is. They want to have vacancy decontrol at all costs because that's how they make money. That's how they get out of rent control, by harassing people into moving out or evicting tenants into moving out. And so we tried to stop that in 2018 with something called Proposition 10 that would have repealed Costa Hawkins, and we lost. We lost because tenants voted against their own economic self-interest. We lost because when you watch an ad on television, my name is Joe Smith and I'm a veteran. I worked hard to get my property and my single family home. Proposition 10 is going to take that away from me. And then you get people like Latino icons like Antonio Villaraigosa, who is the mayor of Los Angeles and a very popular character, even now, in spite of all the scandals he's gone through. And you have him telling Latino voters that Proposition 10 is against their own self-interest because the other side paid him $90,000 to cut a little ad. And then there was someone from the NAACP that did the same thing. So now tenants are confused about which way to go. Always follow the money. If you've got tenants' rights organizations supporting something, then that is what you need to be voting for. If you've got a bunch of landlord organizations supporting something, then that's not going to be in your own economic self-interest. So we lose. And immediately after this, the Alliance of Californians for Community Empowerment launched a campaign for statewide rent control. And in all honesty, when I got this call saying I was licking my wounds and trying to figure out how not to get revenge on every bozo that refused to walk a precinct. At the time, I was representing a huge number of tenants in non-rent controlled buildings, and we encouraged them to get involved in the campaign. And we had like less than a 1% participation rate, even though they had a direct interest in getting this law passed so we could protect their units, and yet people weren't getting involved. And I was sort of pretty fried by that. And I get this call from this organizer that we're like going out and protesting the day after we lost against the big funders, and then we're launching a statewide rent control campaign. I'm like, in my head, I'm thinking you people are crazy, but I always do what ACE tells me to do because I'm a good ACE soldier. And I signed up and I was at the demonstration and we worked for this statewide rent control bill and we got it. And why did we get it? Because the landlord lobby thought, well, let's give them this rather, it's not the best law. There's some 4 significant loopholes in it. Let's give them this because maybe they won't go after repealing Costa Hawkins again. Well, in November of 2020, even though we had gotten the state rent stabilization law in January of 2020, we tried to repeal Costa Hawkins again. Again, we lost because it's the holy grail to the landlord lobby. So they put out a lot of confusing advertising again, and we cannot counter that confusing advertising because tenants don't get involved in enough numbers to counter it. So that is a pitch for getting involved. There's also a law called the Ellis Act. The Ellis Act was passed in 1985. And what it does is you have a rent controlled building. The units are protected. The owner wants to get out of rent control. They can evict all of the tenants all at once, as long as they promise they're not going to put them back on the market. They have to keep them off the market for 5 years. Sometimes what they do is demolish. Sometimes what they do is, well, Jack. Sometimes they demolish. Meet Jack. Jack is my little buddy who sits at my feet all day long and then barks. There he goes. You've got, they have to take all the units off the rental housing market so they can demolish, build something else, convert them to condos, etc. We've lost a huge number of units to the Ellis Act. It's also used as sort of a boogeyman. Sign this voluntary agreement and move out voluntarily, or we will Ellis the building. Let them Ellis the building. You will do better under Ellis. Because of laws like Costa Hawkins and the Ellis Act, economic growth and wages haven't kept up with the cost of housing. So the cost of housing has skyrocketed, but wages have not. And so you've got situations where, like for instance, this actually the skyrocketing of the rent started, this latest round of it in May of 2016. Between May of 2016 and September of 2016, the cost of a single in Pico Union went from an average of $800 a month to an average of $1,100 a month. And by the following February, it was up to 13. Um, and that happened throughout the county. And in fact, it's a national and international phenomenon that the cost of housing is going up. And why does it go up? Because it's a basic necessity. People are going to pay what they have to pay, and because landlords have no restrictions. So rents go up because they can go up. And what tends to happen is a landlord decides to try to get $200 more from the next tenant that they rent to, and then the landlord across the street sees that, and oh well, so I'll go for 250, and then another one's going for 300, and before you know it, there's been this spiraling up that is based on simply the fact that the landlords can raise the rent and the tenants will pay it. And it's funny to me how people's mindsets change. I had a young man tell me, yeah, I really need to stay here because my rent is very reasonable. His rent to live in what was basically a shared room, so it was in a 3-bedroom apartment, 2 people per room, so common in use of common area, for $1,500 each. So that means 15, 3,000, 6,000, 9,000. Someone was getting $9,000 a month for that unit, and it was actually a master tenant subleasing to these other tenants. Now, it was a luxury building, beautiful apartment, it had a swimming pool, etc. But still seems outrageous to me that he thought $1,500 a month to share a bedroom with someone was a reasonable amount of money. It was in Hollywood, right? There were all kinds of reasons why it was that much, but it's still outrageous. So people get used to these higher rents and then don't question the higher rents. Okay. I'm moving on to another subject, and that is that there is no eviction moratorium. There has never been an eviction moratorium. On March 4th, the governor had a press conference, issued a press release, and what the governor said is, I am issuing an eviction moratorium, when in fact he did no such thing. The only thing the governor did is issue an executive order saying, local government, you are free to pass laws to protect your tenants. I'm giving you the power. It was the equivalent of a doctor coming upon a dying, bleeding patient on the ground, and instead of applying a tourniquet, saying, nurse, nurse, come, take care of this. The nurse being the local governments, and local government came along and said, oh my God, that looks bad. Let's put some band-aids on it. They didn't clean the wound, meaning they didn't eliminate the rent debt, and they didn't put a tourniquet. They put band-aids. The state Supreme Court looked at that and said, that doesn't seem like that's going to work. And so they put a tourniquet on the wound. It was called Rule 1. Between April 6th and October 5th, we had Rule 1 to protect tenants from eviction. An eviction could be filed, but a summons would not be issued. And the summons is what you need to move the case forward. Rule 1 resulted in a decrease in eviction filings from 3,381 a month to 258 a month average in LA County. It was significant. We were still inundated with clients calling because people were getting notices, were being harassed, were being kicked out illegally, but the number of eviction filings themselves went down because of Rule 1. But, the Supreme Court got sued, 2 lawsuits. This is not judiciating, this is legislating, not your job. And I'm not going to say how I stand on that, but the message to the governor was, you have to do something about it. Then the legislature and the governor passed 3 laws. AB 3088, AB, I'm forgetting them now, they come up later on the screen. And those 3 laws have been the statewide protections for tenants facing eviction, and also brought some rent stabilization protection to tenants that were not otherwise covered by the Tenant Protection Act. So we had protections, but no moratorium. Evictions are allowed to be filed. On the local level, the county and 40 of our local cities, I'll show it to you in a diagram in a minute, passed protections as well. So tenants were protected by the state protections and by local protections. And I'm also going to explain how what protections still exist right now. In addition to all of that, there was a federal protection under the Center for Disease Control. Now, truth is that protection didn't really help a lot of people in LA County because between the state and the local protections, most people had all the protection they needed. What the CDC order did is people who had already been in eviction proceedings before the pandemic started could not be evicted during the pandemic if they were being evicted for non-payment of rent, no fault, or no cause. That law was declared unconstitutional, I think, about a month ago. And so we no longer have that protection. Again, no moratorium, we have tenant protections. In order to take advantage of those protections, you have to actually do something. You can't just, you get notices, you ignore them. Oh, I don't have to do anything about this. Oh, there's a moratorium. There is no moratorium. You have to respond to what you're getting. You have to respond to notices to go to court. Now, this is how we assess a case, how we evaluate a case. And this is why there's no such thing as a quick question. I have a quick question. Well, before I can answer your question, I need to know, do you have any kind of rent subsidy on your unit? Do you have a Section 8 voucher? Are you living in public housing? Are you living in subsidized housing? Are you living in a tax credit building or what they call low income housing? Are you living in public housing? If not, is there a local rent stabilization law that applies? For that, I need your address. There are local laws in Baldwin Park, Beverly Hills, Culver City, Inglewood, Los Angeles, Santa Monica, West Hollywood, unincorporated LA County, and there's an eviction protection law in Glendale, but they can raise the rent to whatever the market will bear and then evict you for non-payment of rent. So it's not a very strong law. In order for me to advise you, I have to know, do you live in one of these cities? And if you do, is your unit protected by that law? So in Los Angeles, everything's protected. Every unit, all residential units are protected, except, and there's 10 exceptions. One of them is if the unit was built after October of 1978. So we need to know the year built. Another is if it's a single family home being used as a single family home. Only one family lives there, only one set of tenants are there, not protected. And then there's another 10 exemptions from the law. And then sometimes within the exemptions, there are exceptions to the exemption. So we need to have a lot of detail about what your housing situation is. If you are not protected by a local law, we have to find out if you're protected by the state Tenant Protection Act, that statewide rent stabilization ordinance that we got passed in 2019 and went into effect January of 2020. In order to be protected, the unit has to be more than 15 years old. It does not protect single family homes or condominiums unless that single family home or condominium is corporate owned. Why do we have that exception? Because as I said, ACE, the Alliance of Californians for Community Empowerment, was at the leadership of getting this law passed. And they have been working with tenants living in housing owned by Invitation Homes, Blackstone, and other major Wall Street investment firms that bought up single family homes during the 2008 mortgage crisis, robbing people of the American dream by making single family homes an investment commodity. And so it was important to ACE that they protect their tenants. And so we got that exception. In every other ordinance, single family homes are not protected. In the TPA, if you live in a duplex and the owner lives in the other unit, not protected. So now once we know which of these laws apply, we also need to know what the COVID emergency laws are that apply. So in September, we passed AB 3088. Then I forget when this was, SB 91, and most recently AB 832. These are the laws that provide protection at the state level. I'm going to explain what protection you had under 3088 and SB 91 and AB 3082, and then what protection exists now that these were not extended except in a very limited way. And then we look at whether there's a local law that applies. The County of Los Angeles has a law that applies to all unincorporated LA County and any local city. There's 88 cities, LA in red. The gray is all the other incorporated cities. If your city does not have a stronger law than the counties, then the counties applies. The CDC order is now over, and the LA and the CARES Act really applies to subsidized units. You also want to know if there's a rental agreement. If that rental agreement hasn't expired, it provides protection. If it has expired and you are on a month to month, every time you pay the rent, the agreement is renewed for the period of your, like if you pay every 30 days, it's renewed for 30 days. So even though it's been at the bottom of a drawer for 42 years, that agreement says something to us about the unit and protections that you have. And so therefore, we need to know what it says. And then what other laws apply? For instance, if you don't pay the rent and you have bad conditions, that could be a defense to the case. If you're being evicted on a 30 or a 60-day notice to quit, is it really discrimination or retaliation for exercising a right that you had? Are there any technical defenses? Did they fill out the paperwork correctly? Does it have all the right words? And if you are disabled, can we make a reasonable accommodation to get you more time into or to otherwise resolve the case? Now, this is the state of California, and this is the LA County area inside the state of California. This is LA County. It used to be one jurisdiction, one government, the County Board of Supervisors. But over time, 88 cities have incorporated. LA is red, the other 87 are in gray. The white areas or blank areas are the areas that are still unincorporated LA County. So for rent control laws, you have to see whether your city has one. For COVID protections, they cover the entire county unless your city has a stronger law. So in order to know what laws protect you, we need to know where you live, the age of your building, how many units are on the lot, and you can use these websites to figure it out. This is a diagram that I created for myself at the beginning of the pandemic to make sure that when I was interviewing a client, I was ticking off all of the applicable laws, right? Like a checklist. I don't expect you to read it. It's what I've said and what I will continue. I will have or will explain everything in all of these boxes. The point of it is to illustrate that all of those laws have created a safety net for tenants during the pandemic. Now, it's not as strong as this net appears to be. It's more like this one. People will fall through the cracks. People will fall through the cracks for a lot of reasons. They'll fall through the cracks because they're not literate and so can't access services, because they have digital divide issues and no one helped them breach or close that digital divide. They'll fall through the cracks because there's 500,000 families in need, and we probably have funding to represent a portion of those, probably about 11,000 out of the 500,000 that are in need. They'll fall through the cracks because they don't pay attention, because they don't listen, because they attend webinars, but instead of attending and listening, they're busy cooking dinner, cooking breakfast, doing their homework, so they're not really paying attention. They'll fall through the cracks because they don't follow directions. So don't be this guy that's falling through the cracks. Be these guys that are squarely on top of the net. Remember that we're in the middle of a health crisis, an economic crisis. 500,000 households are unable to pay their rent. Landlord harassment is on the rise. We ran some statistics in September of 2020. I should probably do it again. And found that there was an increase of 1,100% in tenants reporting harassment. I decided to eliminate from that figure anybody who was reporting lots of texting, lots of emailing, or lots of phone calling, because there are solutions to that. Just block the damn calls, right? And when I limit it to landlord coming to knock on the door and aggressively pursue the tenant over rent, over moving out, etc., it was an increase of 352%. And when you add, and when you calculate illegal utility terminations and illegal lockouts, which is right here, an increase of 75% from pre-pandemic numbers. It is what's keeping us busy, right? This constant illegal lockouts and harassment. People will also, though, fall through the cracks because the laws are confusing. And so you come here and you listen, and even if you're paying attention, you don't quite get it. And so you get it a little wrong. And so then you do something a little wrong. So it's important for you to come back, keep coming back. Someone asked me the other day, do I have to come to the webinar? And I said, of course you have to come to the webinar. Come to the webinar until you can teach the webinar. When you can teach the webinar, then you don't have to come to the webinar anymore. Then you just have to come up whenever the laws are changing. The other thing that is both confusing and a reason people will fall through the cracks is that the protections expire. So the county protections kept expiring every month and then every 2 months. And because of that, the rent-related county protections are preempted by the state law. And when we lost the state law, anybody protected by the county law lost those protections as well, which is different from the city of Los Angeles and city of Pasadena and a few others that passed their laws before the state started passing their laws. So their laws are not preempted, and those tenants have a lot more protection than tenants whose laws were preempted. And then lastly, there is not enough legal assistance. I have to tell you, I get up at between 3 and 4 every morning. I'm usually still working at 10, and on a lucky day, I get 15 minutes to take a break for coffee in the morning, 15 minutes at noon, and 15 minutes at dinner. And sometimes I'm having those meals while I am doing a webinar, and you are asking a question, I'm stuffing my face. Why? Because the need is that great. And all of my staff is working very hard. People are working way more hours than they're being paid to work. Why? Because the need is that great. But that means we need you to recognize that we are a ship in a storm, and everyone can survive if we work together. And that requires you acknowledging that you're not any more special than anybody else on this call. Everyone is special. Everyone is entitled to representation and to help, etc. And the way that we are going to be able to make that happen is by all of you being self-empowered, by educating yourself, by coming to the webinars, knowing your rights, so that it is easier to represent you and less time consuming to represent you, and then we can help more people. That's how we're going to get through this storm. Sometimes people are like I get people are stressed out, and I get that they need more individual attention than we can give them. But please keep in mind that the insistence on a lot of individual attention means that somebody else is not going to get help. So, so be deliberate about how you seek help. People want my phone number. I don't give it out anymore because I don't have time to call you back. If you need me, you come to office hours, and Kevin will put the office hour times up on the chat again so you can write them down. Okay, at this point, I'm switching the subject again, and now I am talking to anyone who has not been able to pay the rent during the pandemic due to a pandemic-related issue, okay? And this is the diagram that explains AB 3088 and SB 91 and AB 382, the state protections. For anyone that was unable to pay rent between March 1st, 2020 and August 31st, 2020, in order for the landlord to collect that rent, they have to serve you a 15-day notice to pay rent or quit. And with that notice, they have to send you an explanation of the law and a blank declaration form. When you get that, you have to send back the declaration filled out within 15 working days. If you do not, you can be evicted for that rent. If you do, the landlord is forever prohibited from evicting you for that rent. So it keeps you out of eviction court. If the landlord never gave you a 15-day notice, to play it safe, you should send our declaration to them proactively to make sure that you're covered by this and they can never evict you for these months. That rent is due November 1st, unless you're protected by a stronger local law. The landlord can sue you in small claims court starting November 1st, unless you're protected by a stronger local law. For rent owed between September 1st, 2020 and September 30th, 2021, same process. If the landlord wants that rent, they have to serve you a 15-day notice to pay rent or quit with a declaration that's blank for you to fill out that explains that you have a COVID-19 reason not to pay it. And they have to send you an explanation, a description of the protections. If you return the declarations and have already, because this deadline was September 30th, paid 25% of the rent from September to September, you can never be evicted for that rent. If you did not do that, you can be evicted for that rent. If you did it, that rent again is due November 1st, unless you have a stronger local protection. We are recommending that people go ahead and continue sending the declarations, both for the past rent and for the future rent. If you didn't pay your rent in October, send the declaration. Why? First, it's the right thing to do. You should be telling your landlord if you can't pay the rent, right? The landlord should know what's going on. Secondly, that declaration works for local protections that require notice, like Pasadena requires you to give written notice to your landlord. So give written notice to your landlord. And number three, it's not going to hurt, right? So it's not going to harm you at all to send that declaration. And you should have already done the 25%. If you have not applied at housingiskey.com for rental assistance, please do that. Why? Because it's an opportunity to get rid of your rent debt. Also, once the application is approved, it provides eviction protection. So if the landlord has filed an eviction action against you, but you have an approved rental assistance application, the case will stop. It pays 100% of the arrearage, and you should keep coming back to the workshops for any updates. Some extra sort of cookies that came out of AB 382. All non-payment cases are masked, and they're masked permanently, meaning nobody can know that you were being evicted. So it comes with protection against, sort of credit protection. To tell you the truth, all evictions are masked from when they are filed, and they stay masked unless the tenant loses within the first 60 days. Then they become public records. But this is an extra way of keeping records sealed. AB 382 also provides some extra protection against what we call pretextual evictions, meaning the landlord's pissed because you didn't pay the rent, but suddenly something that you've been doing for 20 years is a problem. Okay, so it provides some protection for evictions that are really about the non-payment of rent, but they're making up some other stuff to be able to get you out. It also, AB 382 requires that the landlord let you know about your right to apply for rental assistance. If you apply for a couple of other things, the landlord, when they file the eviction action, has to declare under penalty of perjury that they are working with to get you rental assistance. And if you get approved, the proceedings stop while the application finishes. And then the last one is the no summons without a hearing to determine if your case is COVID related. This is the declaration that we are recommending that you use. Maybe between now and next week, I'll update it to move September up here. For October, just write it in and just go ahead and keep sending them. You can get this declaration at StayHouseLA.org. Let's go on that website briefly right now. So if I go to here and then go to See, I'm already on the website, but I want to go back and show you how to get on it. So I go to StayHouseLA.org. I hit enter. I can, all these languages. I can go into this Know Your Rights, get legal help, or find a workshop. So you come on here and you can find out about this ACE clinic at the YMCA. You can find I think this one's even in person. Yeah, it's the first in-person clinic. I'm not doing that yet. There's a CES clinic. Oh no, this was this morning's clinic at 9 a.m. that I did. I don't know why the one at 1 o'clock isn't on here, but we need to get them on. On Tuesday, October 26th at 10, you can go to a CES clinic. So there's other clinics that you can go to, just register and go. You can find out more, you can get legal help. You fill out this questionnaire. It takes about 20 minutes and you are immediately assigned to a legal services program and a CBO. And then you work with them to figure out how your problem is going to get resolved. Or you can find out more about your rights. So this is a basic explanation of people's rights under COVID. And you can also find out the LA County law, the City of Los Angeles law, what national protections still exist. And then here under other protections in LA County, here's a guide to COVID-19 protections. It kicks up this spreadsheet that's going to open up. And so here's the law, federal, California, LA County, and then each city. You find your city to determine what protections still exist in your city. You'll note that a lot of them expired 9/30, but if you go to Pasadena or Los Angeles, they're indefinite. Maywood, indefinite. Here's another indefinite. Torrance, indefinite. And each of the laws are a little bit different, so you can take a look at the law that applies to you. That's StayHouseLA. Going back to the PowerPoint. This lovely collections of letters came to me because I actually am a member of some of the landlord associations. I'm a member because I am a landlord. I have 2 units in the back, rent-controlled units. The history of how I became a landlord is an interesting history in and of itself. But it is important to know what the enemy is doing. I was actually a member of AGLA until they sent out this thing that they wanted to use our dues to sue the city of LA, I think, and I didn't want my dues to be used for that, so I resigned from AGLA because the vote won. So we're no longer AGLA members, but it is good to know what the enemy is. I would read that publication religiously because then I would figure out, oh, this is the next trick up their sleeve. So important. But anyways, I got this from one of this packet one Friday night. It arrived, and I sat down and read it and thought, wow, they did a great job. This is a little notice that is supposed to go to every tenant to explain the state laws. And before a landlord can file for eviction for any rent between March of 2020 and September 30th of 2020, they have to send this to every single one of their tenants. And if they don't, it's a potential defense. This is the 15-day notice that was being recommended by this group. It has a huge defect in it. It doesn't elect forfeiture of the lease. So at the end of the court hearing, if we lose, we just have to pay the rent. But this is the one that was being recommended and the one that most landlords use. This is a 2-page explanation of the law that's supposed to go to any tenant that has not paid the rent. And if you read it, if you take the time to read it, you'll find it says what I've told you. It says they did a great job at explaining the law. And this is the declaration being proposed by that group. If you read from here to here, you will note that it is identical to ours, except this, what's called the attestation, just says signed under penalty of perjury. That is all that is required to sign something under penalty of perjury if you are signing in California. If you're signing a document for California and you're outside of California, you have to say, I declare under penalty of perjury under the laws of the state of California that the following is true and correct, or that the foregoing is true and correct. And so, because so many people were staying with family and out of state, we changed the attestation to the longer one, but that's the only difference you will find between what they're suggesting, between this declaration and our declaration. The other difference, though, is that theirs doesn't say who it's from and who it's from or what months it is. So what we recommend is you get one of these, you look at ours, you compare it, you add the stuff that's missing, you cross out anything that's extra, and you send it back. And if you're confused, you come to one-on-one after a webinar or to my office hours. This is a proof of service. The person that sent it to you needs to have filled it out. People get scared when they get notices, like the level of panic for tenants. You have to remember it's just pieces of paper, pieces of paper. A piece of paper can only hurt you if you move too fast and you get a paper cut. So don't be afraid of the papers. Read the papers, read them. And if you don't understand them, one-on-one, come to a webinar, sit through the webinar, go to a one-on-one, and or come to office hours. People want to know when they have to start paying rent again. Well, the economy is opening up. You know, I went out to dinner with a friend yesterday. The restaurant was full. Restaurants are open. Like our economy failed because so many people in LA County work at restaurants or other service. Pat, please mute yourself. Kevin, can you please mute her? Work in businesses that were closed down during the pandemic. Businesses are opening back up. It's time to apply for a job. It's time to make sure you're vaccinated, make sure you get your boosters. Make sure you're wearing a mask. If you're using a cloth mask, make sure you're double masking. Make sure you're lowering your potential viral load. Should you come in contact with someone that's infected, wash your hands regularly, sanitize regularly, etc. But we are getting into a place where, whether it's safe or not, we are going back into the world. Whether it's completely safe or not, the economy is opening up. So it's time to think about that. When should you start paying your rent? Is when you have a job and you can afford to pay it. People, I have a 3-day notice to pay rent or quit for October. Well, what should you do? If you want to avoid eviction, pay the rent. If you don't have the rent, then don't pay the rent. Do not put it on a credit card, in my view. Do not put it on something that's going to accrue huge interest. Do not get a payday loan for it. You'll never get out from under that. You should apply for rental assistance and see what the landlord does next after the 3-day notice expires. Okay. So when should you start paying rent? Prospective rent? When should you pay? October, November, December, when you have a job and you can pay it. And you should probably be thinking about how you're going to get a job so you can pay it, or what your permanent solution is going to be. Because I think there will be about 3 more months of rental assistance. And then after that, I don't know what's going to happen. And so we need to start figuring out long-term plans for folks. When is the rent due is the second question. When is the arrears rent, the rent that you didn't pay between March and September due? Under the state law, November 1st. November 1st, 2021 is when the landlord can start going to small claims court to sue you for that rent. November 1st, 2021. But if you have a local law that was already explained in place in September of 2020, such as Los Angeles and Pasadena, then it's X number of months after the state emergency ends in that city. So in Los Angeles, it's 12 months after the mayor declares that the state of emergency is over. in Pasadena 6 months after their mayor and city council declared that the state of emergency is over. Have they declared that yet? No. When are they going to declare it? I don't know. We have to pay attention and watch the numbers and the numbers they go down, 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 and then they start spiking back up again. And so unclear when that will be declared. What we want you to do, and we used to say to stay out of eviction, follow our step-by-step, because the eviction protections for October, November, December are gone. So you can be evicted. Local laws provide you defenses. You can maximize your protections by following our step-by-step, and you must apply for rental assistance. And you must join ACE or the Tenants Together or your tenant union in order to mobilize for stronger laws. So I'm moving on to a new subject, and that is, can I be evicted for other reasons other than non-payment of rent? So the person who said they're here with a 60-day notice to quit, no cause. I'm answering your question now. You need to listen now. Anyone with an eviction notice for any other reason, a verbal threat for eviction for any other reason other than non-payment of rent. The first thing we have to know is, are you protected by a rent stabilization law? So again, where do you live? Are you in one of these areas listed here? Unincorporated LA County, Baldwin Park, Beverly Hills, Culver City, Inglewood, Los Angeles, Santa Monica, or West Hollywood? If you are, is your unit protected by the law? If it isn't, does the State Tenant Protection Act protect your unit, right? And then we have to know, once we know that, we have to know if any COVID protections still apply. So during the pandemic, you were protected from no cause evictions if, so AB 3088, SB 91, and AB 382 provided protection until the end of September. That is now gone. So I actually should cross that out because it's gone. The CDC provided protection until October 4th. That is now gone. So what is now left is the LA County protections that are now in place until the end of January, and LA City protections that are in place indefinitely. And I think that even though we are recording, I am going to fix these right now. So this is now gone. So we're going to cross them out. And this is in effect until 1/30/2022, and then it will disappear. And LA City has no end, and some of the other local cities have no end. You have to see that tracker that I took you to. What about no fault evictions? These are the reasons to evict that are not your fault, but they are part of they are allowed under rent stabilization laws. So if you're being evicted for an owner or family move-in, in the city of LA, not allowed during the pandemic. In the county of LA, it wasn't allowed until a couple of months ago, and now it is allowed with some limitations. So we have to look at that carefully. In other cities, you have to look at the tracker. Same thing with manager move-ins, Ellis Act, substantial remodel. These are all no-fault evictions where there is protection in the LA County and in LA City, and you have to look at your own city tracker to see if there's still protection in your city. There is also protection in LA County until January 30th. I'm going to fix that as well. January 30th, 2022. You cannot be evicted for having extra occupants, pets that are in violation of the lease, or the noise that they make in LA County until the end of January. In LA City, no end. You can also see if your city has similar protections. But there are still evictions allowed for nuisance, crimes, and other lease violations. I'm dealing with a case right now. Prohibition against smoking on the lease. Tenant continues to smoke. It's a tough one because it's an elderly person with a very bad addiction that can't really go to the local park across the street to smoke and is a chain smoker. But that smoke is affecting other tenants. So it's not like we can say that she should be allowed to smoke. And it's not like her doctor is going to give us a doctor's note that she should be allowed to smoke. And so it's a real difficult problem to resolve. If you get into a fight with your neighbors, you might find yourself facing an eviction for a nuisance. If you threaten your neighbors, if you have loud parties, you shouldn't be having parties right now. Those are probably a nuisance. I had a case, I think we've resolved this one already. Someone kept going to take out their trash without a mask. To tell you the truth, I felt conflicted. Like, how inconsiderate is that? I am like the what's it, social distance diva is what my mask says. I will go up to people and make them stand 6 feet away from me. When I'm in line, I make the person behind me go 6 feet back, and I force the 6 feet in front of me. A lot of we had COVID in my household, and we had COVID in my household because my spouse you know, uh, didn't want to be that guy, right? The person that makes people stay 6 feet away. And we could have died from COVID, right? So we all need to be that guy. We need to be the enforcers of social distancing. We need to make sure we're 6 feet away from other people. We need to be masked. We need to be gloved. We need to do all of those things. So I will tell you that my interests in keeping people safe from COVID were very much at odds with this anti-masker, but we were able to finally she agreed to wear the mask and the case got dismissed. Okay, so you can still be evicted. I want to talk a little bit about harassment. If you are here because you are being harassed by your landlord, this is your time to listen, okay, to listen closely. So harassment is on the rise, primarily by master tenants and small landlords, and there are no good solutions. We call the police takes the side of the landlord. And we had a demonstration where literally it was actually an illegal lockout, tenant being illegally locked out, and the police showed up in riot gear with tear gas. It was at the beginning of the pandemic, and it was around the time of the Black Lives Matters protests. So tensions were particularly high between the community and police at that time. But still, the police tend to take the landlord's side. We should insist on criminal prosecution. Now, our movement is divided on that because a lot of people in the tenants' rights movement are abolitionists, so they want to abolish the criminal justice system. And I guess I want to abolish it except for landlords. So the crimes committed by landlords, like illegal utility terminations and illegal lockouts, are not prosecuted as crimes. And it's very, very difficult to get prosecutors to consider them crimes and to actually enforce the law. So if you're a single mom and your kids are hungry and you go in and you steal from a supermarket, you're going to jail if you get caught. But if you're a landlord and you kick out your tenant illegally without court process, you're not going to jail because they don't treat that as a crime. And I think that's wrong, frankly. You can file a civil lawsuit. That's a lawsuit for money. You can also make that lawsuit to put you back in, although it takes so long that most courts won't do that. And frankly, we don't have the resources to file those lawsuits. So you can file a civil lawsuit to be compensated for what you were damaged. Unfortunately, it's hard to get lawyers to take those cases um, for a lot of reasons, including lawyers that file civil lawsuits get paid a percentage of the recovery. Everybody should watch Aaron Brockovich. The lawyer pays all the costs and gets a percentage. A percentage of a low value case is a little bit of money. And so it's not enough to attract most private practitioners. Plus, if it's small mom and pop landlords doing this, and these are uninsured claims, collecting is going to be impossible. I used to do this when I was in private practice, and too often the landlord declared bankruptcy, and then we didn't see any of the money. So it is very hard to get lawyers to file these claims. You can file for what's called injunctive relief, or you might know it as a temporary restraining order or a restraining order. There are also problems with that, including that the burden of proof to get a restraining order is higher than just in any regular civil case. It's called clear and convincing evidence. And so you might not be able to meet that burden. And there aren't enough lawyers to do this. And if you try to get a restraining order and fail, it will bolster your landlord to harass you more. So you have to really think this through. We're trying to get more funding so that we can do more to help people with restraining orders. But right now, we do not have the resources. In my view, the cure for harassment by landlords is renter power. And what you're seeing on the screen is one form of renter power. There is nothing more powerful than being in a room with a bunch of activated, politicized, powerful tenants. You join these organizations and you will become a powerful tenant. You will go from being meek, mild, frightened, a victim of your circumstances, to being a powerful agent for change, not just for yourself, but also for others. So please get involved in your tenants union, in the Alliance of Californians for Community Empowerment. If you could put those links back up in the chat, Kevin, and or Tenants Together. ACE and Tenants Together are statewide organizations. The tenant unions are local organizations that that have an international network. And ACE also operates on local chapters that are part of a statewide organization. And all of those organizations and many more are part of Housing Now, which is a coalition that does legislative advocacy in Sacramento. So get involved. It's good for you. It's good for the movement. It's good for you. It's good for other tenants. In the meantime, if you're being harassed by your landlord, ask yourself, how is my landlord harassing me? Well, they keep sending me texts. Simple. Block the text. There is no obligation for you to be engaging the landlord on text. You send one text. I'm going to tell you what to say in it right now, and that's it. And then you block the text and you don't get tempted to go look, because if you block the text, there's a place where you can go look at them. Don't look at them. Okay. Don't bother. Don't answer. They're sending you a lot of, calling you a lot, then block the calls. Caller ID. They call you from another number and you realize it's them, hang up. You send them one text, one email, letting them know you're not taking their calls, and you just simply stop answering. Email, auto reply to emails. The message that you want to put is the same as this, which we put on your doors, because if they're coming to knock on the doors and windows should have one of these signs. You joined one of the organizations, and you can say, I'm a member of ACE, the statewide tenant and housing rights organization. We have been informed of our tenants' rights. And then basically it says, stay away from this door. And if you insist, you are being recorded. Okay. Basic message, your actions violate state and or local emergency tenant protection measures. Please stop texting, calling, emailing, knocking on the door. Put all requests into a proper notice so that I can take it to my tenant union, tenant rights organization, and our solidarity attorney. During the pandemic, we've gotten new protections against harassment. There are increased penalties in state laws. There's a county anti-harassment ordinance, a city of LA anti-harassment ordinance. And so there are more laws to protect you. Not enough lawyers to help you enforce those laws. Yesterday, we filed 3 lawsuits against 3 landlords who had been harassing their tenants in violation of the county ordinance. There was a press conference. There's probably going to be some press reporting about it. And that is being used as a deterrent against landlords. Changing the subject again, now I'm going to talk about your rights if you live in what's called a bootleg or illegal unit, the converted garage, the accessory dwelling unit that's not supposed to be rented. I had a guy living in a lean-to in someone's backyard. People who are living in trailers or mobile home parks in, not mobile home parks, but mobile homes parked on a single family home lot. No rent is due. These are all illegal uses. You don't have to pay rent for an illegal use. And you can't stay there indefinitely. It is an illegal use, probably unsafe. You need to be moving towards finding where to go. Um, because you're eventually going to be forced out by the code enforcement authorities. If you live in a rent controlled jurisdiction, you'll get relocation assistance before you're forced out. But in some of the other jurisdictions that don't have rent control, the code enforcement authority might just put a red tag and force you out without notice, without court process. This has not been happening during the pandemic because most of the local protections say that you can't be evicted because a unit is bootleg during the pandemic. So right now, folks are relatively safe. Before calling code enforcement, you have to be prepared for being booted out. Um, Although there is a growing movement to legalize these illegal units. Now I'm switching to cash for keys. If your owner is trying to get you out by offering you cash for keys or a voluntary vacate agreement, then you should be paying closer attention right now. This is very common if you live in a rent stabilized building. Usually it happens when a new owner buys, but sometimes it can happen when the kids inherit or the owner wakes up and realizes, damn, I'm only charging $600. I could get 25. And so now you're getting offered cash for keys. Sometimes it happens just because there is a new owner. It's not rent stabilized, it's not particularly below market, but the owner realizes if I get everyone out, slap some paint, do a little bit on the surface remodel, I can get in tenants that can pay more. And so I've seen it happen where what was keeping the rents low was not rent control or rent stabilization, but rather just, the place is not as spruced up as it could be. So they get everyone out, spruce it up, and then raise the rent to market. What you have to remember is these are voluntary vacate agreements. You do not have to accept. You do not have to accept. Very often I'll ask tenants who have these voluntary vacate agreements, okay, so what would you like to do? How would you like to resolve this? And the answer, 9 out of 10 times, my landlord wants me to move, or my landlord wants. I'm not asking what your landlord wants. I'm asking you what you want. Well, my landlord, and what does that tell me about that relationship? It tells me that tenant has no power in that relationship. And the first thing we have to work on is that tenant's sense of self and getting them to realize that they do have power in this relationship, that they need to know what they want and not tell me what the landlord wants. You should not accept unless it puts you in a better housing situation. And frankly, for me, that's home ownership. Or there's a couple of creative things that people have come up with lately. LA is like, if you get displaced out of most units in LA is, people are priced out of the LA market. But we have been able to get people enough money to buy. I used to say to buy in LA, but now really people are buying in Riverside, Baker, Palmdale, Lancaster, the desert communities surrounding Los Angeles. So if you're willing to go to another community, you can buy a house in an outside community where land values are not blown out of your reach yet. Um, I also have tenants who are being evicted for under the Ellis Act, and we push it out and give them get them as much time as possible and get them as much money as possible. But if we really, really cannot win, I've had people do some of the following. I've got a few people who are moving to Merida, Mexico, right? I've got had a few people move to Utah, Arizona, um, several people just back to their own countries. They've come here. They came here with a dream of getting enough money to go back home, and then this makes it a reality. I have a guy who bought a piece of land on a beachfront in a lake called, I think, Catamaco, and now has a little restaurant and his house behind the restaurant, and sees I don't remember if it's the sunrise or the sunset on the beach every day. That's a good plan, right? But if you can't get yourself in a better housing situation with the money that we can get you in a negotiation, either in a cash for key settlement or as part of an eviction, then you need to fight to stay. unless you absolutely cannot win. And for more details on that, I need you 9 o'clock any Saturday morning, or Kevin will put right now the recordings to two of those Saturday sessions. They're each a little different. So watch both recordings and come next week. Still on cash for keys, don't accept without considering organizing to save your building and your community. Okay. So really, when we do this work, we really prefer to go in this direction. And we have had some very successful battles to save buildings. Um, Now, ultimately the decisions are up to the tenants, and sometimes battles go for a really long time, and then people will give up. So, but I can give you some success stories. Near the Sears Towers, there is a 1,200 unit development called Wyvernwood. The tenant association there is del Comité de la Esperanza. They have been in a battle against their landlord to save their homes since 1997, I think. Um, Maybe 80, no, 1997. Um, and they have defeated the landlord's efforts to convert the place into something luxury kind of apartments, much like the Americana on brand. And they have done it successfully. Now, during the course of the years, some people have left. The Tenant Association doesn't have as many members as it did in 1987, but it has nonetheless managed to preserve that development all of these years. The tenants in the Santa Fe Art Colony have done the same. The tenants at Lincoln Place fought a very, very long battle, several decades battle, eventually kind of lost. Eventually we lost most of the development, but the people who stayed to fight till the end got to stay in a part of the development that was segregated out as part of the negotiation for those families. And then finally, don't accept without talking to a lawyer. Okay. Uh, Even if you decide that you are going to move out, we will get you a lot more time and money in the deal than you will be able to get for yourself. The dreaded for sale sign. The for sale sign goes up. Oh my God, for sale sign. We gotta have a for sale sign. Can we get the for sale down sign? Okay. Landlord has a right to sell. The for sale sign has a right to be up. If you don't want to be bothered by prospective purchasers, put a sign on your door that clearly says not to knock and to call the number on the for sale sign. Your rights and obligations do not change because the landlord does. So your new landlord will have the same rights and obligations as the old one. You have the same rights and obligations as the old one. Whatever your rights you had before, you still have. What changes is attitude. The new owner will likely want to do things that are different than your old owner. And then that's where the harassment starts. They will do the cash for keys. All of these things will happen that will make it more difficult for you to be there. So you have to prepare for that, mobilize, be ready to stand up for the harassment. New subject, illegal lockouts. So as I said, illegal lockouts are on the rise. At the beginning of the pandemic, we established this emergency lockout hotline and a rapid response mechanism, meaning a whole bunch of activists on a text string, so that if someone was being locked out, we just had to activate those activists, and 20 people, 30 people would show up. If you were already locked out and had just been locked out and you could prove you were a tenant with a rental agreement or rent receipts or other proof, they'd put you back in. The landlord calls the police. The activists stay to intervene with the police. We were seeing higher than a 99% success rate in stopping lockouts at the beginning of the pandemic. Um, it's been it's been what, a year and some months. People have gone back to work. The number of activists available to respond to rapid response is much less. And so sometimes we issue a call out for rapid response and we don't get anyone. I try to intervene by having the tenant call the police, intervening with the landlord. We try to do that kind of a negotiation, but it's not nearly as successful. Um, if we are not able to get you back in, you can sue for damages if you've been illegally locked out. Again, hard to find lawyers to do it. There are several people on this call that want us to help them do that. We don't have the bandwidth to do it. I can give you, Kevin, can you put the private practitioners in the chat? These are the private practitioners who have indicated a willingness to look at these cases. If you've been illegally locked out and you want to sue for damages, please feel free to call one of them. If you can't find anyone, you can come back to my office hours. I'll see what I can do, but most of these cases are going to end up in small claims court. This number rings to someone's cell phone, often mine, sometimes other people's. Please do not abuse it. The other day at 2:30 in the morning, someone who had come through the webinar called because they got a 3-day notice. They just come home from work and they had a 3-day notice waiting for you. So they thought it was okay to call that number at 2:30 in the morning. They got a piece of my mind, okay? Because it's not okay. It's not fair. A 3-day notice is not an emergency lockout emergency, and it's not appropriate to come and call for the status of your case or about a notice in the middle of the night. You're going to wake someone up, okay? This is an unfunded volunteer hotline, and so please do not abuse it. Use it only if you're being illegally locked out and it's a true emergency. It is illegal to harass people about their immigration status. You can't ask about immigration or citizenship status if you're a landlord, or threaten to call ICE or retaliate. This next section is about the eviction process. I'm going to run through it very quickly because this is really the subject of the Saturday at 9 o'clock webinar. If Kevin could put the link for that webinar on the chat right now, you get 2.5 hours, sometimes 3 hours of this. So evictions process is long, and with a lawyer, we have a 98% success rate. And while this is not a guarantee, it shows that we know what we're doing. Success is either winning or a settlement that is favorable to the tenants. Evictions start with a notice that give the tenant X number of days to do X. And these notices take many shapes and forms. Examples. So they usually say X number of days to do something, or, and then the words can be quit, vacate, move out, terminate tenancy. It all means the same thing. If you do not do what the notice says in the number of days that the notice says, legally the only thing the landlord can do is file a complaint for eviction with the court, and then they are issued a summons. Right now, during the pandemic, they will only be issued a summons if they say they're cooperating with rental assistance under penalty of perjury. So summons is issued, and then that summons and complaint packet, which is 20, 25 pages, sometimes more, gets served, meaning brought to you at your home. Do not avoid service. If there's a knock on the door, hello, who is it? Process server, open the damn door, take the papers. If you don't, they will say that they gave them to you. And if you don't answer, you're going to lose automatically. And then it's a harder battle. You have 5 working days to answer. You file an answer. There's a whole bunch of steps that happen. And with a lawyer, 75% success rate. This is the summons. It is the paper that gives the court power over you. Again, it's supposed to be served in person, and you have 5 working days to answer it. And if you read this, it says a phone call is not good enough. A letter to the court, not good enough. It's a specific document that has to be filed. This is the complaint. It is attached to that summons. It could also look like this, and basically it tells the landlord's side of the story. You might see this, a prejudgment claim on top. Flip through the pages, you will find the summons. This is different. This is the notice of unlawful detainer. This comes in the mail. When the landlord files the complaint, the court sends you this to let you know, to warn you it's been filed. The reason for that is that even though you're supposed to be given the summons and complaint in person, you'd be surprised how often landlords lie about giving it to you. So now you're on notice that you're expecting it. And if you don't get it within 3, 4, 5 days of getting this, just go to the court, get a copy of your file. You make an appointment, you call the court, lasuperiorcourt.org on the website, you call the court, you make an appointment, you go, You give them your name and your address, or this case number if you've gotten this already, and you ask them for a complete copy of the file and a printout of the registry of actions, and then you reach out for help. This is the second page. I'm seeing the Spanish version of that page. 5 days to answer. This is what the answer looks like. It's a very specific judicial counsel form that tells your side of the story. After the answer is filed, there's lots of steps during which we can negotiate in order to get a resolution that you want. 90% of landlords have representation in eviction court in LA County. 12% of tenants are represented in eviction court. And 99% of tenants that go to court alone lose. And if you lose, you end up getting evicted. And this is the notice to vacate. And this is the notice that the sheriff puts after they have kicked you out. The notice to vacate comes with 2 other sheets of paper. The date that is here is the last day you can be there. The next day, the sheriff can come and lock you out. Sometimes it takes them another day or 2 after that, although during the pandemic, they have been faster. How long does it take between you lose your loss and the sheriff lock you out? And pre-pandemic, it was 14 to 21 days. During the pandemic, it's been more unpredictable. The procedures have changed, other things have happened. So sometimes the landlords and their lawyers make mistakes and don't get the paperwork right to the sheriff. And so it can take longer to get the sheriff lined up to evict you. But what I have noticed is once you get this notice to vacate, it was rare pre-pandemic for the sheriff to be out anywhere. Like certainly not that I've been doing this since 1981 as a student. Since 1981, I've seen 4 times that the sheriff came out the day after. 3 of those times was during the pandemic. Okay, so it can have, actually now it's 5 times, 4 during the pandemic. So because there's fewer cases, the sheriff, once they have all the paperwork lined up, they can come out faster than before. This notice of eviction is what they put on the door after they lock you out. We do not recommend that you break back in after you've been locked out, not even as a protest, because it could be prosecuted as a felony. So I guess the correct thing to say is if I've been arrested 32 times for nonviolent civil disobedience. I am not a stranger to protesting and violating unjust laws, but know that this comes with a potential felony charge. So you may not want to do that. Most protest actions are trespass actions that are misdemeanors. And so it's just a different weight. These are contact numbers for the city and county of Los Angeles. I'm going to talk a little bit now about documentation. It is essential that you document anything that is happening in your tenancy. If you have bad conditions, you should have picture and video of those conditions. That picture and video should be uploaded to either emailed to yourself or uploaded to a Google Drive. Make sure if you're uploading it that the date that you took the picture or the date that you took the video stays clear in the pictures. Sometimes when you upload, the date shifts to the date of the upload and then you can get confused. So you need to know when, date and time that you took each picture. If you're going to send anything to the landlord, you need to make sure you videotape that you did that. You should be sending things like the declarations by US mail and putting it in a Dropbox at the property and sending it by email or delivering it in person. And you should document with video that you did that. If you don't get a declaration from the owner, then go ahead and send ours by going to the post office and taking outside of the post office, taking an uninterrupted video showing that you have filled out and signed the declaration and showing, so you show the actual declaration and showing the envelope and that is correctly addressed, and say, I'm now going in to mail this and get a proof of mailing. It cost about $1 and it looks like this. Also, why not put one in the Dropbox at the building if one exists and send one by email and or go in person if it's safe to do so. If you get a declaration from your owner, then return it as instructed in the notice to pay rent or quit. If they tell you to mail it, mail it. If they tell you to email it, email it. If they tell you to deliver it, deliver it. But also send it by email, since that is a way to prove that you've actually done it. How to make a video. You must show the filled out form and the signed declaration actually being put in the envelope without any interruption. Show the correctly addressed envelope, and without any interruption show that you're walking into the post office, putting it in the Dropbox and handing it to the owner. Send the video to yourself to avoid the phone fell in my toilet phenomenon, which appears to really happen a lot when people are having problems with their landlords. Phones break. You need to make sure that you've sent it, that you've preserved it in some way. These instructions apply anytime you send any important document or rent to anyone. Document everything with video and photos. Keep a calendar or journal and always send the evidence to yourself the same day. How to pay rent like a pro. Never pay in cash. Never pay in cash. Electronic payments are okay, and so are direct deposits if you've been instructed to do them, but they can't be mandated. The preferred method is through a cashier's check, which you buy at a bank. It's guaranteed funds. But acceptable payment are money orders. We recommend Western Union and Continental Express. Please don't be my client who decided to go get MoneyGram and then didn't realize that after a certain amount of months, you can't get your money back from MoneyGram, and so they lost a significant amount of money. Western Union and Continental Express ask how long you can have the money order before it becomes void, and make sure you return it back in for a new one, or cash it and put it in your bank after making a copy of it to prove that you had the rent before it becomes moot. We don't recommend the US Postal Service because these are very hard to replace. Checks are not a good idea because they're just a promise to pay in the future. If they bounce, you got a problem. And bounce checks are what main reason for evictions. Pay as instructed. If they tell you to mail it to the North Pole, mail it to the North Pole. But I know his office isn't in the North Pole. I know his office is on First and Spring Street. Mail it to the North Pole if that's where the notice says. I have fought a lot of cases where the tenant got a 3-day notice to pay rent or quit. It said to send it to a different address, but they chose instead to send it to the regular address, sometimes because they didn't read the notice and sometimes because they knew that the notice was wrong. Do it as instructed. If you do it as instructed and it gets lost in the mail, then it's on them. If you don't do it as instructed, then it's on you. If there's no instructions on how to pay, in person is better. And make sure you get a receipt and make sure the receipt is correctly filled out. Tenant pays $1,000 in cash. The receipt only says 100. Tenant doesn't notice. Then they only paid 100, okay? Because you have to have a receipt that says 1,000. Sometimes tenants will come in and they've got zero balance, zero balance, zero balance, but suddenly there's a balance here. Don't accept a receipt that has a balance here if you don't have a balance, okay? Make sure you read it carefully. It's not good enough that it says January 1st, 2022 here. In order for this to be rent for January 2022, it has to say rent for, and right here, it has to say that you're designating this payment for rent for January 2022. If you don't designate what month the rent is for, then they can say, oh yeah, but like 4 years ago, you missed a payment. So we've been applying each payment, one payment back. So you always designate both on your payment instrument, on your check or money order, rent for, the address for the month of, the month and the year. And on your receipts, the same thing. You can drop rent in a Dropbox as long as you take a video of yourself doing it. You can also send it by priority mail with delivery confirmation, no signature required, and again, do the video. Why no signature? Because if you require a signature, then they no one's there to accept it. And so the postal carrier takes it back to the post. It goes back and forth. It gets lost in the vortex of certified mail hell, and then we don't know where the payment is. So no signature required. It provides tracking. You can prove you sent it. If they refuse it, they refuse it. And again, follow the videotaping instructions. When you buy money orders, fill them out at the counter. On the memo line, rent for a month and year for the full address, including the zip code. Separate the stub or the carbon from the actual instrument as soon as it is filled out. Take a photo. If you lose the money order and the stub or carbon, you cannot get your money back. Keep them in two separate places. And when I say two separate places, I mean two separate places, not two separate places in the same apartment. I have the case of the person who kept them in two separate places, but the landlord, we think, no witnesses, broke in and stole both. And so she lost over $10,000. And we have the case of the apartment building that caught on fire and they lost all their money. So be very, very careful. If you lose both, you lose your money. If you lose a blank money order, anyone can put whatever they want. If the owner refuses the payment, save the instrument, but watch out for expiration dates, or put it into a separate savings account, which is the safer thing to do. But make sure you have a copy to prove that you bought a money order on time. Again, we are the Eviction Defense Network. We're part supporters of the tenants unions and of the Alliance of Californians for Community Empowerment. Don't you want to be one of these people, right? I love this picture. You want to be one of these powerful, happy, empowered people, okay? Please get involved. Also proud members of the Right to Counsel Coalition. Again, if you want help, you can do one of the following. To get help from the Eviction Defense Network, your case has to be in the Compton court. That's for City of LA residents only. Downtown LA, Pasadena, or West Covina courts. You can go to edn.la, fill out the eviction prevention form at the bottom right of the first page. Wait for a response. We are super, super inundated with requests. If we do not respond to you, then come on any Monday, Wednesday, or Friday at 6 p.m. to these office hours. You will be held in the waiting room and admitted one person at a time. There's no presentation. The status of where you are in line is posted in the chat every time I bring somebody in. Please try to come on Mondays and Wednesdays. On Fridays, honestly, I'm often too tired to really give people the attention they need. So on Fridays, I'm now starting to just screen for emergencies. I only want to be on for an hour. I need to know whether you should really just be coming to the webinars on Saturdays or coming back on Mondays. And I don't really do a lot of counseling on Fridays. So try to come Monday and Wednesday. Again, the immediate lockout number is here. If your case is not in these courts, you want to get help at StayHouseLA.org. And this is the digital divide literacy number for StayHouseLA.org. Okay. I'm going to show you how to get on the website. So if you come over here and you go to EDN, encryption and weird things. Okay. We probably want to get out of here. So let's see. EDN.LA. It is that simple. EDN for Eviction Defense Network.LA for Los Angeles. No comms, no orgs, no nets, no nothing else. EDN.LA gets you into this beautiful website with this beautiful picture. And you just come down here, click on Eviction Prevention Form, and fill this out. Under where did you hear about us? Referred by X to the Saturday 1 p.m. webinar. Attended Saturday 1 p.m. Elena Popp asked me to fill this out and come to her office hours on Monday. You fill out the rest of this, you press submit, do it once and only once. For a while, there was a glitch and it was coming up with an error message, but we get the email. So this generates an email, even if you get the error message. It generates an email to 4 people. One of the 4 of them should then send you an answer. Sometimes my staff jump the gun. If you don't, if you still want to talk to me after you submitted this, you come to office hours, even if my staff has answered you. But it is best to follow their instructions unless you are confused and want to talk to me. Okay, so back to the PowerPoint. These are the webinars: Tuesday at 6, Thursday at 5, Tuesday in Spanish, Thursday in English, Saturday at 1, bilingual. The subject here is about the same. And in fact, we're recording this presentation so that I can stop saying it over and over. We're going to play this presentation Tuesday at 6, Thursday at 5. And then I'm going to see how long it is. And then we're going to do one-on-one counseling immediately afterwards. We're probably going to just play this presentation on Saturdays at 1, or you can just listen to the presentation on your own time and then come to the one-on-one consultations. The eviction process webinar will continue to be a live webinar with a Q&A at the end. We usually don't have time for the one-on-ones on Saturdays because it lasts till about 12:30, and then this starts at 1, and I need a break, frankly. But that one also, Kevin has put the recordings for the last 2 weeks on the chat, and where it changes enough so that if rather than watching the same recording twice, you should watch different recordings, because I tell different stories in that one each week. And then again, the office hours are Monday, Wednesdays, and Fridays, starting at 6 p.m. Please don't show up at 8 thinking that you're going to get seen, because I kind of pace myself based on the number of people that are on at 6. And so if you come on at 8, you're going to get a message from me that you're too late and that you need to come at 6. Not that I want to make you wait, but if I only had 4 people or 5 people or 6 people at 6, and I gave them each time so that I could get off the call by 9, which is what my goal is, and then 10 of you come in at 8 o'clock because you didn't want to wait, that just doesn't work. And don't come in any earlier than 5:55 because we're using that Zoom for other things. And so you're disrupting other meetings. So you should be coming in 5:50, 5:55. Make sure you're addressing all your technology issues. And so that we open up at 6. And then you watch the chat for what the order is. Okay. And with that, I am going to stop sharing and stop recording.